Good morning and good afternoon, everyone. Thank you for joining us today at our Fasken Labor, Employment, and Human Rights webinar, New in 2025, Preparing for the Year Ahead. Now, of course, we all know there's nothing happening out there in the world right now, so this will be a very short presentation. And of course, I kid with that. We have a chock-a-block full agenda for you today. A little bit different than a lot of the webinars you're used to seeing us put on, where we will focus in on maybe one topic. Today, we're going to jump around through a few different topics, things that we've picked out that we want to make sure are top of mind for you, or trends you might be missing that we're seeing percolate a little bit coming into the new year, or as the year turned from 2024 to 2025, and highlight those items for you. So as 2025 progresses and we go wherever we're headed, you've got these ideas at your fingertips. My name, of course, Marc Rodrigue. I'm a partner here in Fasken's Toronto office. I'm going to introduce my colleagues, my expert colleagues who are here today shortly. But I want to draw your attention first to the technical logistics that are outlined on your screen right now. And I'd also like to draw your attention to the survey and the CPD certificate points, particularly that you'll see here. You'll be hearing from us in terms of your thoughts on our presentation, and in particular, your thoughts on what we might do in future that would be useful for you. There will be QR codes and links at the end of this presentation for you to fill in that survey and for you to obtain certificates, whether if you're in Ontario, Quebec, or BC. We'd really appreciate a couple minutes if you could spare us to fill out the survey. Joining our esteemed panel today are my colleagues Marie-Gabrielle Bélanger, a Montreal partner with our Labor, Employment, and Human Rights group. We've got Bruce Graham, another partner based in Calgary, and our colleague Andrew Gould, who is an associate based here in Toronto. There is one topic we asked you, of course, for questions ahead of time, if there's anything you wanted us to address. We noted that many of you do have questions and concerns around immigration issues, and that may be a CPD on its own that we may put on in future, given the interest. But we did want to give you, in a one-stop shop, as best we could, answers to multiple immigration questions by way of one of our most recent write-ups on all of the changes in immigration law we've seen recently and that are continuing into this year. You should be able to find that write-up now in a link in the chat box for our presentation. So if you are interested in the immigration pieces, please, you can click that link and get information from our expert immigration colleagues. At this point, we'll move on to our presentation. And as I said, we've got a chock-a-block agenda for you today. We've tried to break it up to talk about some key legislative changes that are coming into force this year, or were passed late last year, that we're anticipating coming into force this year, things you should be aware of. There are some provinces you'll see that have been more active than others, and jurisdictions that are more active than others, and we're trying to hit as many as we can. We'll talk then a little bit about case law trends, things we've seen, particularly around the turn of the year, the good, the bad, the ugly, and what you might see percolate more this year. We'll talk a little bit to wrap it up about managing through uncertainty. We all get the circumstances right now in Canada, and our economic conditions are uncertain. Every day it feels like there's new news for us to digest and try to read tea leaves as to where things are going, what our workforce needs will be, future in the short term and in the long term. And so we want to talk a little bit about making some decisions, if hard decisions need to be made, about how to manage through uncertainty, how to manage through challenge, how to manage a workforce, particularly if we need to condense the workforce or think about whether we need to even see certain operations on a moment's notice. So we'll talk a bit through some of the options there just to remind you what those are and have them top of mind, and we'll try to get to some questions at the end. So without further ado, I'm going to pass the mic over to my colleague Andrew to talk about some of the legislative updates.
Okay, thanks very much, Mark, and thanks to all of you for joining us today. as Mark mentioned, we're just going to start by going over a few of the key legislative updates that either passed late last year or that we're going to see come into force throughout 2025 that we think people should be taking note of. Quickly, we're going to go over some of the Working for Workers Acts that have some relevant changes coming up. We're going to touch on some of the changes to the Canada Labour Code that came in last year, and in particular focus on the ban on the use of replacement workers. And then I'm going to pass it off to Marie-Gabrielle to talk a little bit about some of the big legislative changes in Quebec, particularly around health and safety requirements, harassment, and the prohibition on sick notes. So beginning with Ontario, there was a period of time prior to this current provincial government where it would be infrequent that we would really see notable changes to employment legislation. And since the Progressive Conservative Party has taken over, and with the original Working for Workers Act in 2021, we've had pretty notable changes to employment legislation, whether it be employment standards, occupational health and safety, or the like, virtually every year. In 2021, 22, and 23, there was one Working for Workers Act introduced each year. And then this past year in 2024, we actually saw 3 Working for Workers Acts introduced. That is the fourth, fifth, and sixth version, with Bill 229 Working for Workers 6 Act coming into or receiving royal assent on December 19th, and actually being introduced under a month earlier. So it came in just kind of under the wire. So I'm going to touch a little bit first on that Working for Workers 6 Act that was passed really quickly, and some people may not have even been aware of, let alone know that it actually received royal assent. So the changes that are included don't necessarily have some of the same notable features as some of the predecessor legislation. The big changes to the Employment Standards Act that were introduced include an introduction of an unpaid 16-week child placement leave, and that's going to be coming into force on June 19th, 2025. That's very similar to the recently introduced child placement leave in the Canada Labour Code that was introduced last year. And it fills a gap that currently exists for employees who have either adopted a child or have had one placed with them through surrogacy, which technically was not caught by the existing parental leave provisions in the Employment Standards Act. There was also the introduction of an unpaid 27-week leave for long-term illness for employees who can't perform their duties due to serious medical condition. This hasn't been proclaimed into force yet, and it will be, we'll be keeping an eye to see when it does. This is also addressing a kind of gap that exists currently in the legislation. And in order to be able to take that leave, we do know that there's going to be a medical certificate required stating that there's a condition that the employee cannot work due to, and a period for which they won't be able to perform their duties. There were also some changes included to the Occupational Health and Safety Act, which have already come into force. Throughout, I will pause and say just that throughout, as we're going through these legislative changes, in the interest of both time and trying to make sure we get through all of the content we have in this presentation, I may not touch on everything in a ton of depth, but if you do have any questions at any point for any of us, please feel free to reach out after the presentation. I know some of these slides may have quite a bit of information on them. So the changes to the Occupational Health and Safety Act, including creating new permissions for the Chief Prevention Officer under the legislation. And that was to, again, establish criteria for assessing training programs that are delivered outside Ontario for equivalency, essentially saying if this training was delivered outside of Ontario or previously taken, will it satisfy the requirements that exist underneath the legislation? Also, creating permission to establish policies for general training requirements, and then also to collect personal information in specified purposes. The bill also created a new employer duty to ensure that personal protective equipment fits properly and is appropriate. And the news release from the province when this was introduced noted that this change was aimed particularly at ensuring that women and workers with diverse body shape are receiving the necessary equipment that fits properly. And probably most notably, the change that got a little bit more publicity was the introduction of a mandatory minimum fine of $500,000 for employers where a second or subsequent offense results in the death or serious injury of a worker in a 2-year period. So not only is there a mandatory minimum that's introduced here, but the language that we've included on the slide is actually what is taken from the legislation. And it does present a bit of an issue because that offense where it results in the serious injury of a worker, serious injury is not actually defined in the legislation as is. So one of the takeaways or the early takeaways from the introduction is that employers will perhaps need to start thinking about how they may resolve charges where an offense is actually has occurred underneath the Occupational Health and Safety Act, and they've been presented with the opportunity to potentially resolve it. If the situation could potentially fall under this category of, an offense resulting in the serious injury of a worker, it may be worth potentially fighting that charge if there's a chance it could again result in within the following 2 years, and the potential liability could climb quite a bit. One of the other changes coming up in Ontario is the requirement to supply certain employment info to new employees. And this was a power that was actually introduced under the Working for Workers Act in 2023. It gave a regulation making power under the ESA to prescribe certain information that needs to be provided to employees in writing and when that information actually needs to be provided. So we've had a Ontario regulation filed which provides that information and has clarified that it's actually going to be coming into force this year on July 1st, 2025. Now, the info that needs to be provided, it's nothing particularly onerous or surprising. As you'll see on the slide here, things like the legal name of the employer, as well as operating or a business name, the contact information for the employer, descriptions of where the employee will initially start performing work, their rate of wages, the pay period and the payday that's established by the employer, which is a necessity under the ESA, and then a general description of the employee's initial anticipated hours of work. This doesn't apply to employers with less than 25 employees, and that includes the new hire on their first day of work. The expectation is that the requirements here will be satisfied where an employee is provided with a written employment agreement. We don't have confirmation that that is the case just yet, but we will expect that guidance will follow in some form, likely in the interpretation manual for the Employment Standards Act that the Ontario Ministry of Labour puts out. And we will be sure also to try and put out some guidance on that if we receive some clarity. Another piece of Ontario legislation that's gained quite a bit of attention over the last couple of years are the new requirements in Ontario for publicly advertised job postings. And these are actually requirements that were introduced in the Working for Workers Act, the fourth and fifth version, and notably required some version of pay transparency in the realm of publicly advertised job postings. So these requirements were actually put into the ESA. However, we didn't have a coming in force date, and we weren't actually given necessarily the parameters of what needed to be disclosed, whether there would be exceptions to these rules. And we did recently get these with a regulation that was filed back in November of 2024. So these requirements will be coming into force on January 1st, 2026, which for the purposes of this presentation will count as something to look forward to, ahead to in 2025, given that once the year ends and we turn over, these requirements will be in place for Ontario employers. So the job posting obligations themselves, the pay transparency one has probably been picked up by most people at this point. And that requirement is actually to disclose expected compensation or the range of compensation for the publicly advertised position. We've gotten exceptions now to understand that it won't be required for positions with, a high level of total compensation that exceeds $200,000, or where there's a range of expected compensation that might exceed $200,000. We also now know that because they've included the possibility to include a range to meet the requirement, that range cannot exceed $50,000. And compensation for the purposes of these job postings has the same meaning as wages under the Employment Standards Act, which will generally capture most forms of compensation other than discretionary bonuses. Some of the other requirements for publicly advertised job postings will be a statement disclosing whether the posting is for an existing vacancy as opposed to building a bank for future vacancies, and then an actual proactive obligation on employers to inform applicants who have interviewed for a public job posting of whether or not a hiring decision has been made within 45 days of the last interview. The interview for the purposes of this is defined quite broadly, and it's specified in the regulation that an applicant can be informed either in person, in writing, or using technology. Along with the job posting obligations, we have some other introductions, which are a prohibition on including requirements for Canadian experience or an equivalent in the job posting. There's a new requirement to retain copies of publicly advertised job postings and any associated application form for 3 years. There is a little bit of uncertainty at this point as to whether associated application forms means on behalf of the employer, i.e. the application form that might be attached to that job posting, or if it means application forms received in connection with the publicly advertised job posting. But hopefully there will be some additional guidance from the Ministry of Labor on that point. And lastly, employers who use artificial intelligence to screen or assess applicants for a job that will be publicly advertised now need to include a statement in that job posting disclosing the use of artificial intelligence. There are some exceptions to these requirements, namely that they do not apply to employers with less than 25 employees on the day the job posting is posted. And then we also received notably a description of what actually would be captured under the umbrella of a publicly advertised job posting. So it is quite broad in that it's any posting advertised to the general public. However, it doesn't include things like a general recruitment campaign, a help wanted sign, postings that are restricted to internal candidates, and then work which is to be performed outside Ontario or performed outside and in Ontario, where that work is not a continuation of work performed in Ontario, which is, again, the language that's used in the ESA to determine whether or not the ESA applies to work in the first place. Also in Ontario, we had the coming into force of the Ontario Digital Platform Workers' Rights Act. This was actually enacted under the Working for Workers Act 2022 and has been a separate piece of legislation for a number of years now, but hadn't actually been proclaimed into force. So we now know that it's going to come into force on July 1st of this year. And the act applies to any worker who performs digital platform work, which is defined in the regulation as paid rideshare, delivery, courier, or other prescribed services, where their work assignments are offered through the use of a digital platform. So along with the some obligations that came in under this act. We have, or pardon me, we have obligations both for the employers, and then we also have some corresponding rights for the digital platform workers that are captured underneath the legislation. So digital platform workers are now entitled to certain rights, which are meant to be kind of corresponding rights that they would receive if they were recognized under the Employment Standards Act in Ontario. And so those are the right to be informed, that is within 24 hours of receiving access to the digital platform. They have a right to a minimum wage, right to tips and amounts earned, a right to notice of removal from the platform, and a right to resolve work-related disputes in Ontario. That last point being notably included, likely due to the outcome of the Uber decision, which made waves a number of years ago due to a mandatory arbitration clause. The Act also imposes obligations on operators, so those being the providers of the actual digital platform on which the workers can access. So some of those obligations include providing a written explanation where access is removed, for why access has been removed, and that has to be given within 24 hours. Operators will also need to maintain a record of the workers who access the digital platform. They need to establish a recurring pay period and payday, which again is in line with the requirements under the Employment Standards Act. And then they also have obligations not to deduct or withhold amounts earned by the worker unless authorized specifically by the Act. These follow similar changes that were introduced in British Columbia. However, there are some notable differences in that in British Columbia, the protections that were brought in for gig workers or digital platform workers, as they've been called in Ontario, were actually done as amendments to their existing employment legislation, whereas in Ontario, they've actually passed a separate act. And as a result of that, gig workers in Ontario are not technically employees, as they would be considered under the Employment Standards Act, whereas in BC, online platform workers, the definition has now been deemed to be an employee under the Act. So we will likely see down the road if there are some unintended consequences of that decision and how to actually set up the gig worker protection regime in those different provinces. I'll quickly touch on changes to the Canada Labour Code that came in last year under Federal Bill C-58, which received royal assent in June 2024. One of the more notable pieces that was introduced in that bill was a broad ban on the use of replacement workers during federal sector strikes and lockouts. And at the time that the legislation came into effect, there was a 12-month countdown to coming into force, which will be on June 20th, 2025. So included in this prohibition on replacement workers is any employee who is hired after the notice to bargain is given. It includes any employee who's hired before notice to bargain if that employee normally works at a different location. Again, trying to prohibit transferring from locations into a bargaining unit location that is on strike or being locked out at the time. Any third parties or contractors, and any volunteer students or members of the public. There are some exceptions to the ban, and that includes contractors who are retained before notice to bargain was given. They may continue to do the same work, and then there is a carve out for the use of workers where there's an imminent or serious threat to life, health, safety, and then the other situations listed here. Bill C-58 also, along with these changes on replacement workers, introduced a new regime for the maintenance of activities that unions and employers need to establish before they're in a legal strike or lockout position. And they also introduced, which kind of coincides nicely with this ban on replacement workers, a ban on crossing of picket lines. And an employer can actually be held responsible where an employee regardless of whether or not they want to be on strike, crosses a picket line. And violations of these new bans are considered an unfair labor practice under the Act, and employers could face fines of up to $100,000 per day as a result. I'm going to now hand it off to Marie-Gabrielle to talk about some of the legislative changes that are of note in Quebec.
Thank you, Andrew. Thank you all for attending. Okay, so let's look at some of the recent Quebec major changes. Bear with me, I could not make everything enter into a 20-minute presentation, and there's actually already a lot of information, I know. So if you work in majority in Quebec, you may already know, or you have already heard a lot about Bill 42, so the Act to Prevent and Fight Psychological Harassment and Sexual Violence in the Workplace. So Bill 42 has came into force on March 2024, but a lot of obligations for employers has came into force during the fall of 2024, and we still see, unfortunately, a lot of employers that are now not compliant with the new obligations, especially with regards to the update on the harassment and violence policy. So I'll touch a note on that. With the modification on Bill 42, the two main goals of the Minister of Labor were to better protect workers who were victims of psychological harassment, for sure, but also to provide a clearer framework for the recourses available. Because I don't know if you're aware, but there were still a lot of employees who didn't know how to file a complaint, where to file a complaint, how would they be protected. So that's actually the main goal of this bill. So it modified two major acts in Quebec, the Act Respecting Occupational Health and Safety and the Act Respecting Labor Standards. And it also has an impact on the Act Respecting Industrial Accidents and Occupational Diseases. So I'll touch a point on that also. So the first major change is the incorporation of the definition of sexual violence within Article 1 of the Act, respecting occupational health and safety. And you can read it, sexual violence means any form of violence targeting sexuality or any other misconduct which is not defined in the legislation. And these misconduct or any form of violence can occur once or repeatedly. So it's really broad, and we have no interpretation of that as of now. But if you enter into the definition of a misconduct that happened once, then it will have some impact for you with regards to the obligation of the employers and also the burden of proof for an employee who files a complaint. So there will be four major changes or amendments to the legislation. So first of all, there's the presumption of occupational injury. We'll see when that happens. A restricted access to medical records, which we were not used to. There's a deadline for the victims of sexual violence that has been updated, and imputation rule that has been changed also. So the first presumption that has been included in the Act is that any injuries resulting from sexual violence within the definition that I just said by an employer or by one of the employer's executive officers are now presumed to be employment related. So it's going to shift the burden on the employer to be able to prove that it's not employment related. The other presumption is that when a disease arises within 3 months after the worker suffered any sexual violence at the workplace, it will be presumed to be an employment injury, and still the burden will be shifted on the employer to prove that it's not employment related. So it will make it a lot easier for employees to claim for compensation. Okay,
So with regards to access to medical records, when a healthcare professional shares any medical information, now the only communication that can go to the employer is the summary of their record of the health record, and it's only the information that is necessary for the employer to respond to the claim. So we were really used to sending a note to the doctor and asking for the employee's medical record. But now, if the employer or if the doctor sends the full medical record, there could be fine ranging from $1,000 to $5,000 for the individual, but $2,000 to $10,000 for legal entities. So we really recommend to making sure that that you work with health professional that knows this rule and that will not share with you all the medical records. So this has came in force on September 28, 2024. There is also a change with regards to the deadline to claim for the victims of sexual violence. So it's been updated from 6 months to 2 years, which is going to give them a lot more time, but which reminds you for employers to make sure that you take notes on everything that happens, because there's a difference to make between harassment in the workplace, which has to be repeated, and the sexual violence, which can happen only once, and we could forget about it. And the last but not the least, because everything comes back to money. The bill amends the existing rule concerning the attribution of the occupational injury. So now the benefits will be charged to employers across all units, making an exception to the general rule that usually the burden of benefits would be placed solely on the employer's side. The employer directly involved in the case. Okay, so the other legislation, the other act that has been modified with the Bill 42 is the Act Respecting Labor Standards. There are a lot of new obligations that came into force last fall. There's the protection against retaliation. There's the obligation with regards to the policy that I talked about a little bit earlier. Punitive damages that can be claimed, and I'll talk a little bit about that also, and amnesty clause that cannot be taken into account when we talk about the harassment or violence in the workplace. So we know and we knew, it's not new, that all employers were already required to prevent and address psychological harassment in the workplace for the employees, but now it's specifically provided that employees that the employer has a responsibility to protect its employees against third parties harassment, so clients, subcontractors, and suppliers, and this is specifically provided in the Act, but now has to be included in the employer's policy. So you have to make sure that the employee knows that you, as an employer, have an obligation to protect them against third-party, any third-party harassment. With regards to protection against reprisals or retaliation, the new legislation also includes greater protection, and this means that employees who have made a report of psychological harassment or employees who have been witnesses in an investigation should be protected against any reprisals or retaliation. And if an employee faces some reprisals, then he could file a complaint for prohibited practice against their employer with the CNESST. So it's like a right that's been added as a protection. And if it's not if the employer does not protect this right, then he could face a complaint. With regards to the policies on the prevention and handling of psychological harassment, I hope that if you are working in Quebec, you all have looked at your policy and updated it. So there's a few things that should be updated if it's not already done. So with regards to risk management, you all have to clearly define the methods and techniques that you will use to identify, control, and eliminate any risks of psychological harassment in your workplace. So it has to be, you have to make it. It cannot be the same for everybody. You have to make your own assessment. So there is also additions with regards to training programs. So information and training programs should be mentioned in your policy, training program for employees, but also training program for those who will be the respondent, the designated person, so the person to receive any complaints and to do the investigation. So they should be trained also, and the training program should be included in the policy. There's also a necessary add with regards to conduct guidelines for employees during work-related social events. And the complaint process should be really clear, and the steps for filing a complaint, reporting, including the identity of the person who is designated to handle the complaint, should be included in the policy. And it cannot be a team. It cannot be like very general. It has to be a person, and there could be additional person, but it has to have a name, an email, and a phone number. Additional things that you should add to your policy would be the measures that you would implement to protect employees against retaliation, just like we discussed. All the process for handling the psychological harassment situation and the investigation, so all the investigation process and what could happen after should be in your policy, and also the measures put in place to ensure the confidentiality of a complaint, which is not anonymous, but it's confidential. And there's also a new delay for retention period for the documents with regards to a complaint for psychological harassment, who is now a minimum of 2 years. There's also a change with regards to amnesty clause in Quebec. So amnesty clause are provisions typically found in collective agreements or employment contracts to offer protection to employees for a period of time. After a period of time has elapsed, and now, even though you can still have amnesty clause in your collective agreement and they still are common, this mention states that employers can consider all past disciplinary actions for misconduct with regards to psychological, physical, or sexual violence. So the amnesty clause for any of these physical, psychological, or sexual violence are now prohibited. Last modification with regards to punitive damages. So previously, if an employment injury was recognized under the legislation, the tribunal would handle a parallel harassment complaint under the Act Respecting Labor Standards would never impose punitive damages on the employer because it's a no-fault regime, and the damages would only be awarded if psychological harassment was found within an employment injury. Now, employees can claim punitive damages in addition to any compensation under the Act Respecting Industrial Accidents and Occupational Disease. So, of course, this was always in the goal to reinforce the seriousness of addressing workplace psychological harassment. There's another bill that has come into place in Quebec last fall, which is Bill 68, that a lot still don't know about. It's the act to reduce the administrative burden of physicians. And mainly what it does is that for a certain period of time, for any health-related issue absence, the employer will not be able to ask for doctor's note to confirm the validity of the absence. And I know it follows a little bit Ontario on that. So the first reading was on May 31st, but it came into force last fall, but some things came into force January 1st this year. And the objective is to free up nearly, a few, and I don't know if the number is actually good, but to free up a lot of medical appointments annually for patients. So according to the Ministry of Labor, this number could be true. So what it does, more specifically for employers, they will not be permitted to request any documentation explaining the reason for the following types of absence. So for three periods of absence, up to a maximum of 3 consecutive days. So for a period of absence, no documentation of any type can be asked for to confirm the leave. Period of absence, for me, just a quick note, my interpretation is that it doesn't have to be a full day, so a half-day period of absence could actually be a period of absence. And I know we're not used to doing so. We have the instinct to ask for justification, medical note as soon as an employee mentions a sick leave, but we have to be careful with that. And the same, so I think this is the same happens to requiring a medical certificate for personal leave. So when an employee is absent to care for a child, a parent, or someone, there will be no. It is prohibited since January 1st to ask for a medical certificate. So the difference between the personal leave versus the medical leave is that the personal leave, you can ask for any other justification except a medical certificate. And for the leave in the event of death, compassionate care, sick leave, domestic or sexual violence, serious illness, all those that we have seen in the past slide, we cannot require any justification unless we're after the 3 days or three periods of absence.
Okay. So switching lanes a little bit from what's happening in the legislatures to what's happening in the courts, and some key trends that we've picked up on, some perennial, some new and developing. I'm going to talk a little bit about 4 key issues that we've spotted in the case law, things that I think will be on your radar and will be on the courts and tribunals' radars going forward as we continue. The first is about remote work and where we're at in 2025. Now, we're going to look at one issue in particular, and that's flexible work arrangements and some of the things we're seeing in case law now. But of course, this is a much broader issue coming back from the pandemic. Of course, we've worked with many of you on issues of bringing people back to the office and how you navigate that. And historically, we've talked about remote work often in the case of accommodation and human rights accommodation, where we might have to look at different environments for people to work in. We're going to leave those aside and look specifically at flexible work arrangements. Now, it's not on your screen, but back in 2018 in Ontario, the legislature here put in place these new requirements around flexible work arrangements, creating essentially the right of an employee to ask for changes to their hours of work, their place of work, their schedule, a whole host of items, and requiring employers to respond and put pen to paper and respond yes, no with reasons. Now that is gone with the change in government from the Wynne government to the Ford government. Those provisions disappeared, but they reappeared in a bit of a copy-paste job into the Canada Labour Code about a year after Ontario put them in. And you see them on your screen right now. It's a whole division now in the Canada Labour Code for federally regulated employers. So for the last 5 or so years, this has been there. I will say anecdotally, I don't think we've seen a lot of action on these provisions. But some of you who are unionized and those of you who are not may have started to hear rumblings. And certainly in the unionized environment, we saw language start to appear in collective agreements that, if they didn't mirror this, started to create similar rights to request a flexible work arrangement. And last year, we saw a few cases. There's two that immediately come to mind in the back half of the year, where provisions in unionized context got challenged. And I'm going to show you one here. This is the last of the Canada Labour Code provisions requiring an employer response. I'm going to talk about one though, and this we love a case of a union representing the employees of another union, which is exactly what this case was, in a grievance. So here, QP 503 had some provisions in its collective agreement for its own workers. They had about 13 people in the bargaining unit around flexible work arrangements. Here we had an employee ask to work from home for 2 days a week. The employer rejected that ask. The employee then asked, hey, can I just work, as needed? And the employer also said no. Now, the language that was put into the collective agreement, you'll see on your screen now, it's about telework. And I want to focus in on a few key features in the language, which says, it's understood due to the nature of the work, where feasible and pre-approved by the vice president or secretary treasurer, employees are permitted to work remotely. And I'll stop there because the keywords are right in there. So, of course, the employer, being a union itself on this one, had said, well, this is not a right. There is no right in this provision. I think similarly, you might argue in the Canada Labour Code, no right to work remotely. In fact, the employer's discretion is right there. It has to be pre-approved by the employer. The employer retains jurisdiction. And so we're allowed not to permit and just make a call and not permit remote work. And that's that. It's our discretion, not much else to it. In this case, and in another one that was decided in the same year involving a MAPCO and the Ontario government, it was found that no, when you read the provision, when it talks about feasibility of working, when it talks about, hey, this is created, there, of course, without this language, the employer has an unfettered right. But the moment you put language like this in your collective agreement, and perhaps, though we haven't seen cases yet, with this being in the Canada Labour Code, it's not so easy for an employer just to receive a request for a flexible work arrangement and simply dismiss it. In fact, there is what I'd call a procedural requirement now for federal employers, arguably, and for employers that have agreed with language in their collective agreements to potentially consider anything in good faith if a request comes, to determine things on a case-by-case basis, to really consider the nature of the work and the feasibility of it, and to have a reasonable response. So in this particular case, we have the arbitrator find, it was a panel, so the panel find the collective agreement created a right to telework with conditions, and it was up to the employer to look at those conditions and say, is this feasible or not, and actually do the homework rather than just flatly reject the request. So an interesting outcome on this one, based on the evidence that was before the panel actually found, realistically, what we heard is it's absolutely feasible for at least 1 day a week. So we will grant 1 day a week. And we will require, after a few months, the employer to look again and see if a second day is feasible and do the homework and have a reasonable level of proof as to whether or not it's feasible. So something for you to keep in mind if you're hearing this at the bargaining table, whether you're federally regulated or provincially regulated, language around flexible work arrangements or working remotely, really could have consequences to it that requires you to do the work if you get a request. And I'm going to hand off some talk right now on offer letter.
Thanks, Marc.
To my colleague in Calgary.
Nice to connect with everyone and be here. So I've got a few cases I want to go to. Took the headline from this of my favorite podcast, Cautionary Tales. If you don't listen to it, it's pretty good. So we're not going to go through too much detail on these cases themselves, but just to kind of pull out a few kind of practical tidbits, just things that we see that are pretty easy to avoid, but unfortunately for some of these employers, it got them into a little bit of hot water. So the first case is this Adams v. Think Labs. This and the next case deal with this issue where sometimes employers will send out an offer letter, which the employee will accept, and then the subsequent agreement follows. Or sometimes you'll negotiate terms and everyone will agree on it, and then the official agreement follows. In practice, where it can be avoided, I would say avoid offer letters, just use the employment agreement. And if you do end up in a situation where you've negotiated terms and they've been agreed upon, or you've done an offer letter and the employment agreement follows, there's always this concept of fresh consideration. So something new for the contract they didn't already have. Courts don't generally care about the quantum of the consideration, but they care about the existence of it. And where there's no consideration, it can result in your termination clause being unenforceable, your restrictive covenant being unenforceable, which is obviously not ideal. So very quickly on this one, essentially, there was an offer letter that went over. It contained certain terms. The employee signed the offer letter, kicked it back. Literally 3 hours later, they sent the employee another employment agreement to sign, but that employment agreement included onerous terms that were not in the original offer letter. And the main one was a without cause termination provision. That termination provision purported to limit the employee to statutory minimums under the legislation. And the court found that that was an onerous term, unsupported by fresh consideration. The employee had already accepted the offer letter. The employment agreement was varying that. And because they didn't give fresh consideration, it was void. And so as a result, this employee was entitled to common law notice instead of limiting the employee to statutory minimum notice. And the difference there can obviously be very significant and costly. The second case here with Hungry Panda, similar situation also out of BC. In this one, rather than it being an offer letter, there was back and forth on emails going over the terms of employment. Finally, they got to an agreement, which the court found was a binding agreement, even though it was sort of, it wasn't a formalized document, but it was terms and conditions back and forth on email. The next day, Hungry Panda sent over the employment contract. It contained a termination clause that hadn't previously been negotiated. The court assessed whether there was sufficient consideration. The employer tried to argue that certain things like benefits and a pay spending account were sufficient consideration. The court found this employee would have probably got that anyways, and it wasn't anything new. And the same result, the termination clause failed, and this employee was entitled to common law instead of statutory minimum notice. So again, just the big takeaway for me is if you can avoid offer letters, do. But if you find yourself in a situation where there's offer letters or possibly this situation of terms and conditions going back on email, and then you put a new contract to that employee, put a signing bonus, put something in there, $50. It doesn't have to be anything crazy. But with that lack of consideration, it's a really straightforward argument for plaintiff counsel to run to undermine the termination clause. So the other two ones to look at are just with enforceability, or a few more cases to look at here of termination clauses and restrictive covenants. So Dufo is an Ontario decision. I'm so happy I practice in Alberta, where we have a little more certainty and sanity than sometimes what I see out of Ontario. But these sorts of arguments are being run here all the time. And obviously, if you're practicing in Ontario, working in Ontario, they're very much live. This case dealt with a number of issues that kind of flow out of that Waxdale case law, which is basically if any part of the termination clause is invalid, the entire clause fails. The interesting thing with this one at the Ontario Superior Court level was the use of the words at any time and sole discretion. So you'll often see termination clauses because everyone drafted them this way forever. It'll say, the employer can terminate your employment without cause at its sole discretion and at any time. And the court looked at that and they said, well, you can't actually terminate at any time because there's legislative protections. For example, someone's on a maternity leave. You can't terminate them at any time. Or they've made an employment standards complaint, so you can't retaliate against them. You can't terminate them at any time. Arguably, the employer is going to comply with the legislation, so it's not going to terminate the employee in that situation. But nevertheless, the court found that these words would have rendered the clause invalid by breaching the statutory protections that an employee has under the legislation. So practically speaking, when you're doing a review of your employment agreements or hiring someone on and you want to get a fresh set of eyes on it or handle this yourselves, just remove the words at any time and sole discretion, because you can terminate at any time without cause unless it would be prohibited by the legislation or unless it would be discriminatory. The point is those words mean nothing. They don't help us, and now they hurt us, so just pull them out. It was appealed, and the court didn't really deal with this issue of at any time. They basically, said it was kind of a novel argument. They left it to a later day, so it wasn't overturned, and the Court of Appeal emphasized the whole, again, concept of Waxdale. If any part of your clause is invalid, the entire clause fails. The employer in this has indicated they're going to appeal it to the Supreme Court, so we'll see what happens there. The last case I'm going to talk about is out of Alberta. It's kind of an interesting one if you're a law nerd like myself. But I think what's interesting is it comes out of a commercial agreement. So there was a seller and a buyer. Buyer takes on the employee. This employee who got substantial consideration from that sale signs a restrictive covenant agreement. Typically in that situation, you're going to get more latitude than a straightforward employment situation where there's a commercial arrangement. But there's this language in here that's bolded, and it was put under the header of a non-solicit. But what it says is they won't accept business from, or they won't accept a client. And so basically, this goes further than a non-solicit. It renders it more akin to a non-compete provision. And with non-competes, you need to have them limited to a geographic area. And this provision didn't have that. And so as a result, the court said this is effectively a non-compete. So it has no geographic scope applied to it. It's not enforceable. I think the takeaway for me, and I see these in a lot of restrictive covenant agreements, is there might be things like no hire clauses. And that goes beyond a non-solicit. So it's one thing to prohibit someone from poaching your employees, but it's another thing to prohibit them from hiring them if they apply on their own volition. And the same would go with a customer or a client. It's one thing to say you can't go poach them, you can't go contact them and try and take over their business. But it's another thing to say that if they come to you willingly, you can't take the work, because that turns it into a non-compete. And courts are often reluctant to enforce these things, and they'll find all sorts of reasons to tank them. And that's what happened here. So again, the lesson really is just to pay attention on the drafting side. So that's it. I kind of burned through that quickly, but I'll turn it over to my colleague, Andrew Gould, who's going to finish up the rest on some interesting developments in case law. Thank you.
Thanks, Bruce. I am going to quickly make an addition to the discussion that Bruce just covered on the Dufault decision, because we actually had a decision in Ontario come out just yesterday, which has now been published, which on the slide that we pulled up, we showed that when it was appealed, the Ontario Court of Appeal said, we're choosing not to comment on the issue of at any time, despite the urging of counsel in the case, because of the importance to not only the bar, but the many employers who likely have employment agreements that have that in them. The Ontario Court of Appeal said, there's other reasons that this termination provision is unenforceable, so we're not going to comment on it. yesterday a decision from the Ontario Superior Court actually cited the Dufo decision, and specifically that a termination provision was unenforceable for containing the language at any time. And that decision was in Baker versus Van Dolder's Home Team Incorporated. So that is now the second case that has used that reasoning to find a termination provision to be unenforceable. Now, should, again, that decision be appealed successfully to the Supreme Court, this decision would likely be revisited as well. But we have at least one other decision in Ontario that has now chosen to follow that reasoning to find termination provisions unenforceable. I'm going to turn now to the decision on your screens, which is Koppel versus Lausanne Homes. And this was a decision from the Ontario Court of Appeal last year, which involved a kind of unique argument, but one that did provide some clarity for fixed term employment agreements. So in this decision, there was a fixed term employee who was terminated 6 months into their employment. And when they were terminated, they were given their ESA minimums. They turned around and filed a wrongful dismissal lawsuit claiming that the early termination provision in the employment agreement was unenforceable, and they were therefore entitled to the balance of the fixed term, which was 6 months in this case, and it was not subject to mitigation. And the employer made a rather novel and creative argument, which was to say, kind of weaponize Waxdale in the opposite direction. And they said that because the termination provision was unenforceable, and Waxdale says every termination provision is then affected and deemed void, the actual term of a fixed term agreement, that saying that the term of this agreement will be 1 year or 12 months or whatever it may be, and then will automatically expire, that should actually also be considered a termination provision. And if one provision is unenforceable, the term should also be unenforceable, essentially turning the agreement into one of continuous employment. And that way the employee wouldn't be entitled to the balance of that fixed term. They would just be entitled to common law notice, which in this case they estimated would be less than the 6 months that would have been due to the employee. That was appealed to the Ontario Court of Appeal, and unfortunately, or pardon, I should say, at the trial, the lower court judge, found that a fixed term defines the term of the contract, but is not a termination clause, and is therefore could not be invalidated by other unenforceable language. That was appealed to the Court of Appeal, and the Ontario Court of Appeal also agreed with the lower court. So to find an early termination provision enforceable, if you want to terminate someone on a fixed term earlier than the term would otherwise provide, it does need to be an enforceable early termination clause. Employers won't be able to find their way to a potentially lesser notice period without that enforceable termination language. On a more exciting note, perhaps the opposite of the Dufo decision, which in Ontario, like Bruce alluded to, we've constantly been battling the courts for the last number of years, trying to find what termination language could be used that would be enforceable. Employee counsel has found a number of ways over the last years to poke holes in termination provisions, and Ontario courts have been more than willing to accept novel arguments and find new ways to invalidate them. And so it was almost getting to the point where not only were employers looking for some sort of certainty or note from the courts that they were willing to uphold any termination language. It was very difficult for counsel to try and draft language that they could say with any certainty was an improvement over prior language that may have been found unenforceable for another reason. it was almost to the point where both council and employers were looking for something from the court to say, listen, if we're not going to be able to have termination provisions that are enforceable and comply with the ESA, then why don't we turn to a model like Quebec has, where reasonable notice is due in all the circumstances. That was why it was so exciting when this decision came out in Birch versus Data Stealth Inc., where an Ontario court finally upheld a termination provision which limited an employee's entitlements to the minimums under the Employment Standards Act. So not only did it have language that said, if you're terminated without cause, you'll be limited to the minimums under the ESA. There also was another provision, which is commonly included, which is to say that the plaintiff agrees to forego any entitlements at common law in exchange for ESA entitlements. So in the situation, upon termination, the plaintiff brought a claim seeking 12 months notice. When they were terminated, the employer had provided 4 weeks of notice, and this employee had only been employed for less than a year, so they were entitled to 1 week. They were provided an amount of notice in excess of that. And the plaintiff counsel argued that the provisions in the employment agreement were void because they failed to specify that to terminate for cause, they must meet the now well-established threshold included in the ESA, which is termination for willful misconduct, disobedience, or willful neglect. And again, this is the exact language listed in the regulations to the ESA. The court fortunately determined that the provision complied with the ESA, and it is just reproduced on the screen there at the bottom of the slide, and interpreted that there was no reasonable alternative outcome that would be contrary to the ESA, given the language used. They did reiterate that where there is any ambiguity, it would be decided in favor of the employee. Again, this is assuming that the employer is the one who is drafting the employment agreement. But in the circumstances, the termination provision was found to be clear and unambiguous. Now, the language has been reproduced at the bottom of the slide here, and it suggests that where it's possible to include relatively simple termination provisions, it might be the best way to proceed, given that we have at least one opportunity here for it to withstand scrutiny. The problem may be where you have perhaps executive employment, situations where employers like yourselves want to provide more than the ESA minimums, and you start building in formulas, opportunities like that to actually provide more than the ESA. You may actually end up building in some language that unintentionally violates the ESA. This is obviously something that we'll be paying attention to and seeing what comes of this, but it's very encouraging to find that a decision, or at least one judge, is willing to uphold some termination language in Ontario.
Okay, let's
pass it off to Marc now.
Let's chat a bit about things that are on everyone's mind these days, especially given the politics of the United States and some of the trends that we've seen very quickly and abruptly there take hold, take shape. One of which is, the buzzwords, and maybe that's the nicest way to put them, especially in the context of U.S. politics right now, of diversity, equity, and inclusion. What we can tell you, unlike the United States, where we've seen action, at least at the federal level, in some cases at the state level, to pull back on legal requirements, not the above and beyond pieces, but the legal requirements. And I suppose in some cases, issues with the above and beyond folks as well. There's no change in Canada that we're aware of right now. The law that governs things like human rights, the law which governs for employers in the federal sector or who are part of the federal contractors program, the employment equity, those have not changed. They are still in place. And one case that came out right at the end of last year really highlights, where we are in Canada, and that in fact there's legal protections if you as an employer start to initiate programs or policies aimed at increasing the representation of equity-seeking groups in your employ. This one comes from Ontario. Again, I'm sorry to pick on the unions. The employer here was a union as well, the Public Service Alliance of Canada, PSAC. And in this case, you have this union. It was very much, I would tell you, on the ball and doing its research and developing its plans. It internally had an employment equity plan similar to what you might find with a federally regulated employer. It had a gender equity task force report. It was hiring into a management position, and it posted therefore a position that was for, and using words right out of the job description, a qualified woman. And this caught the attention of the applicant in this case, who, just happened to be a lawyer, go figure, and who brought a claim of sex-based discrimination against PSAC, saying that they were not permitted to restrict applicants to so-called qualified women. Ultimately, at the Human Rights Tribunal, with all of this evidence of the work PSAC had done with its employment equity plan and its gender equity task force report, showing that there was a need to increase representation among its management ranks in particular, and the fact that the tribunal took a form of judicial notice that management positions and gender equity in management is something that is a societal issue and prevalent, led to the conclusion that, yes, you're allowed to do this. It is sex-based discrimination, but like many of the other provinces, Ontario has protections for employers who are aiming to increase equity for disadvantaged persons or groups, that design a program to do that, and that it's all tied together. So applying a test here under the Human Rights Code, the tribunal found that this was okay, and the application was dismissed. I think the lessons to be learned here from this, and just generally, again, the fundamental law around human rights, protection of certain equity-seeking groups, of requirements, particularly in the federal government, and I believe too with the Quebec government in terms of employment equity, have not really changed. The base level is still there. Employers, coast to coast to coast, have choices of whether they do more than the base level. And certainly, unlike in the United States, I don't think we've heard any rumblings of any form of prosecution for going above and beyond. But certainly for employers who are worried that programs they have may be challenged now, especially in light of the political climate, this case shows you the sort of homework that you can do to defend those programs. So making sure you have an analysis of your workforce, making sure you're designing programs that make sense, that are rationally connected to what your workforce looks like, are things you can do to, do your best to prevent a successful challenge where you're trying to implement programs like this. The other thing I want to just draw to your attention, it's going to be no surprise to anyone that the President of the United States is getting name dropped in cases. And I expect that will happen even more so as we go forward. In light of the economic uncertainty that continues to occur given pronouncements, I want to say on a daily basis, but I think we have a few days of reprieve here and there involving Canada and impacts to the Canadian economy. Obviously, I know the premiers are all in Washington right now, pitching their counterparts not to put tariffs on Canadian goods, among many other economic ties and economic policy pieces that I'm sure they're lobbying on. But right before the end of the year, we have a decision that is from an interest arbitration, where the interest arbitrator took into account, now that Donald Trump, then I guess president-elect, was making pronouncements about tariffs, about the uncertainty in the economy, about what that means for bargaining and collective bargaining, and arbitrators finishing off the collective bargaining process and interest arbitration. And I expect this is the tip of the iceberg, because I think we're going to start to see much more push from employee side counsel and the courts around things like reasonable notice in wrongful dismissals and things like that, where the economic uncertainty, the landscape is just simply going to be taken into account going forward, with or without much evidence. So something for you to keep in mind. I think this will present challenges for all of us, but something we need to keep into account when we're designing our workforce strategies. Speaking of workforce strategies, and speaking of economic uncertainty, and who knows what tomorrow will bring in terms of pronouncements, let's take the final section here of our presentation to talk about some workforce options. We won't spend a ton of time on these, just highlighting pieces that are commonplace, things for you to consider. If you're facing economic circumstances or operational concerns that are going to require you to make decisions about the size of your workforce, whether that's to downsize, whether that's to take a break, to try to furlough folks, put them on layoff, things that you can keep in mind. Certainly what we tell you is to try your best to get ahead of it, to think about it, to have a plan. Many of the options, depending on the size of your workforce, are going to require some coordination, both from a legal side of things, from a communication side of things, and in some cases from a government notice side of things. So make sure you've got a plan and an eye on the future with your operations teams. Let's talk through or think about where you're going to have to navigate among things like your policies, things like your collective agreements, things like your employment contracts, and carefully consider the risks coming from those as well with all of these options. One I'll get into right away. It's something that I think a lot of people here are, for better or worse, intimately familiar with from the pandemic period is layoffs. Whether they're, looking at temporary layoffs where we don't want to let our workforce go, but we don't have work for a bit or all of a sudden, and we need to move quickly. Just remember from your time in the pandemic, even now, the rules on this have not changed. So various provincial employment standards legislations have provisions permitting forms of layoff. Every province has its own unique blend of what's permitted. But what you need to be concerned about in the non-union environment is that a layoff could be a constructive dismissal, even if it's allowed under employment standards, could be a constructive dismissal. Someone can claim they're being let go. You need to take a look at your employment agreements, see if you've contracted over this issue. And of course, in a unionized environment, you need to check your layoff language before you act and make sure that you're acting in accordance with your collective agreement. Pass it back to Bruce for some more.
Thanks, Mark. Yeah, I'll be pretty quick here so we leave time for questions, but just a few more pieces on how we kind of handle this or potentially have to handle the fallout. There's voluntary measures. These are things you can do with your employees to make changes to the terms of their employment. This would be in the context primarily of, there's not enough work. You don't necessarily want to trigger a termination. You may not want to lay them off. Some employees would rather have some work than no work. So this is just sort of a summary of the different options that are out there. Reducing compensation, reducing hours, taking a leave, entering into a voluntary work sharing agreement, or potentially a separation agreement. The key with all of this is voluntary. You need the employee's consent, and it should be papered. It should be in an agreement. And you should be considering the consideration issue as to what's being given to these employees to ensure it's an enforceable contract. Involuntary measures. So this is sort of things we can do short of termination, short of layoff. An employer always has some latitude to make changes to reduction in pay and reduction in hours. The big risk is always constructive dismissal, so unilateral and fundamental changes to the terms of employment that result in the employee being constructively dismissed. We want to avoid that. There's no perfect science on this, but certainly you can reach out to counsel for discussions about what are permitted. Generally speaking, reduction in wages on its own at sort of 10% or less is unlikely to trigger a constructive dismissal. But if that's packaged with other changes like a reduction in hours or a reduction in responsibilities, that can still give rise to a constructive dismissal claim. I generally would advise, anytime a reduction in compensation is 20% or more, you're in the red zone for sure in terms of risk. There's a federal work sharing program. Won't get into the weeds on it, but essentially this can be done with consent of the employees, and you can result in a situation where the employee is working up to 60% less and the government is stepping in to help fill the gap with some of the wages. If you are looking at a reduction in force that involves outright termination, you need to be looking at, well, what are their statutory entitlements, contractual entitlements, common law entitlements, and in Quebec, entitlements under the Civil Code. One thing to note is the sort of scarcity of work. What we saw in the pandemic is because there's financial or economic difficulties facing the employer, this doesn't justify a termination, and it doesn't result in a lesser notice period being awarded. In fact, in some decisions, it can result in a higher notice period being awarded to the employee. And that's because the availability of alternative employment for them is harder and it's more difficult to find. And lastly, if you are looking at terminations of a number of employees, there can be obligations under virtually all legislation about group termination. So a certain number of employees at a certain site within a certain period of time. And this can result in entitlements out to those employees depending on the province, but it certainly will trigger obligations on the part of the employer. So if you are looking at reductions that you think could be significant, it's best to have a plan like Marc was suggesting on that and to ensure that we're lined up to notify the government. So I think just, again, managing through this, like Marc was indicating, seek advice, come up with a plan, reach out to council, and these are sort of things we're primed to help on. Unfortunately, we got a lot of experience of it during the pandemic. And, some of those lessons will be helpful now because there is less uncertainty in the law as to how employers, what their obligations are and what their risks are when faced with deep economic uncertainty. So that's it for me. Thank you.
Now, prior to today and during the course of our presentation, I've noted that there are questions. We'll try to get to as many as we can in the time we have, and thank you for engaging with us on this. One of the questions we had was if we could comment a bit on AI and how that will impact employment. I'll just make a couple brief comments on that. You heard Andrew already say, at least in Ontario, with respect to certain transparency requirements for job applications and processes. There's now requirements coming in that require you to disclose if you're using an AI tool. That, as far as I know, might be the first one in Canada to have that. And I would expect as this progresses, we may see more of this and disclosure of use of AI. I think for you also going forward, if you haven't taken a look at some of your policies yet, and you are concerned about the use of AI, you may be using it as a tool and it can be very helpful. But I think one of the key concerns we're going to start to see percolate is employees putting confidential information into AI tools that you don't control for the purposes of doing their work. And how does that affect you with your confidential information? How is that governed by your policies? Always a good idea to take a look at that risk. Make sure you're communicating properly to everyone what they are allowed to put in AI and any AI tools that are outside your company and what they are not allowed to do it. Because, I think with the tools such at our fingertips these days that it's probably more use than we even know among the workforce and more confidential information leaking than we would care to like to see among that. We did have a question, I'll throw it to you, Andrew, about digital platform work and what's covered here by the legislation. The question's about, could it be as simple in terms of coverage as using an app like WhatsApp for the delivery of your work, where you just send work assignments into the WhatsApp, and I guess that's the only way you're communicating with workers, and they decide to jump on it or not. Is that something that could be covered by the Act, do you think?
Yeah, thanks, Marc. So under the definitions that we have at this point, it doesn't look like that would be captured. Now, it's still very new. We don't have any cases out about it. We don't even really have guidance from the ministry in terms of the boundaries of the definitions that are included for both the digital platform workers and operators, because the corresponding obligations would flow with those definitions. But as it stands, in reading the definitions, it seems like that would not be the case. It's meant to capture specifically where that platform is provided, or sorry, used for the provision of payment, rideshare, delivery, courier, or other prescribed services. So I guess in a certain circumstance where WhatsApp was used specifically for those purposes, I guess there'd be more risk likely with delivery or couriers. It could be captured, but I would probably take a long look at the definitions for anyone who might be concerned about whether the act would apply, and see if you may be able to amend the way that the business is done if there are concerns that you would unintentionally come under its purview.
Great. Marie-Gabrielle, we had a few questions actually about the I would say the leaves protected from asking for certain medical documents, and particularly the 3 days off, and whether it's 3 days off 3 times, so I guess 9 days, up to 9 days, or how that works, just to clarify.
So it's up to 3 days annually. So it's a total of 3 days, or a total of 3 incidents, up to 3 days annually. So it's clear when you read the section 79.2. However, no employer may request the document referred to in the first paragraph for the first 3 periods of absence, not exceeding 3 consecutive days taken annually. So it's a combination, and it's a total for 1 year. I just see that we also had a question with regards to the violence and the sexual violence, and I dropped this very, very quickly in my presentation, meaning that harassment can happen more than once. It's not, I didn't mean that. I did mean that if you want to fall into the definition of harassment, it has to be a repeated incident. And if you want to enter the definition of sexual violence, it can be only 1 incident. And I wanted to make the distinction because I see we have a question, and I wanted to make sure it was clear.
Perfect. Thank you for that. We had a question about what happens when we speak about remote work and seeing some of the case law or flexible work arrangements. What happens if outside of a unionized environment where there's, language in a collective agreement, or even in one, if you have a policy about flexible work arrangements and how you're going to approach them, would that create a right to telework? So much like the cases I spoke about, I don't think it would create an absolute right to telework, but I do think you could be held to your commitment, right? So if your commitment says that you're going to consider them, and there are factors to consider, like in the collective agreement where feasibility was language there that had to be considered, then you're making a commitment to do it. In a non-unionized environment, I'll say, the employee ability to challenge a decision obviously is much more limited. In a collective agreement situation, there's recourse to a grievance procedure, but you can imagine cases coming where, an employee may challenge an employer's decision under a flexible work arrangement policy, may hold the employer to it, and I suppose in a worst case scenario, quit and allege some form of dismissal or constructive dismissal, and an employer's failure to abide by their own policy and consider a request in good faith. I think those are plausible scenarios. So if you do have one, make sure that we're applying it. We're, doing the work that we said we would do under the policy if need be, and trying to avoid a scenario where we're going to be caught out, as in the cases I showed you, where the adjudicators say they came to you, they asked you, you didn't really even consider it, like you didn't do the homework. So think of it that way. Now, Bruce, we've got a couple questions about termination clauses, and I'll give you them both separately. One is, if a termination clause is found invalid, is the entire clause going to be found invalid, or part, going to be found invalid, and does it invalidate the whole agreement?
Yeah, it's a good point. So it can invalidate the restrictive covenants as well in the agreement where there's a breach of the legislation, and usually that's the other term that's probably most important aside from the termination clause. So I think the lesson that we see all the time and kind of hammer home a lot, it's just sort of like doing those reviews of your termination clauses, either regularly or anytime you're onboarding someone. Not a bad chance to have someone look at it and see if we've kind of got the latest and greatest in there. My advice always is enforceability is a moving target. The goal lines are moved by the courts in some ways that we can't predict. But having an enforceable termination clause is so helpful. So many of the disputes we see are over, that issue, and where both parties have certainty as to what happens, people can just move on. You can save a bunch of time, and as charming as we are, you don't have to call us and deal with us. So hopefully that answers that question.
Yeah, and we had this question about will a severability clause help us, or will a savings clause help us? And I think the only comment, I would share with you there is we've got plenty of case law now that says, well, in a commercial context, it might, but this is employment law and it's got its own rules. So we've got cases out there that say that it won't. I'm not saying that you should not have it in your agreement. We absolutely should, where it makes sense. But it's not the parachute that we had hoped maybe it once would be. So to save us. So. I think that we're right about on time. We've held you for a minute. Classic on my part to run overtime, but I'll hand it over to MG to wrap up our session today.
Thank you, Marc, and thank you all to all the viewers and all Bruce, Andrew, and Marc for joining us today. So I think you'll see information on your screen for CPD credits for Ontario, Quebec, and BC, and links that have also been added to the audience chat, if I'm not mistaken. So if you don't get a chance to claim your certificate today, don't worry, they will all be sent next week. I hope you all learned something today. If you have any additional questions, feel free to add them in the Q&A or to contact us directly. We'll be happy to answer you. And thanks again for coming, and have I think we can say all a great afternoon for now. Thank you.